All rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. Good morning. This is the time set, pardon me, for oral argument. Our case number UB220286, Taylor Hauser versus the Arizona Department of Economic Security, and SPT-P former 7261910. Each side is allocated 20 minutes for oral argument. Appellant, you may reserve a portion of your time for rebuttal if you wish to do so. If you wish to do so, you'll need to keep track of your own time at the podium clock. Out of respect for counsel and to avoid any embarrassment, I would encourage those in attendance to make sure that your cell phones are off so our proceedings aren't interrupted. We've read the briefs. We've conferenced the case. We'd encourage you to keep that in mind as you present oral argument today. Our proceedings are being recorded and will be posted to YouTube in due course. So please, as you begin your argument, state your name and the party that you represent. With that, Ms. Falgood, you may proceed.
Good morning. May it please the court, my name is Joanne Falgood with Guidant Law, PLC. I'm here on behalf of appellant Taylor Hauser. Thank you for granting the oral argument in this case and for hearing this case. I am going to try to reserve about 5 minutes for rebuttal. I recognize that's my job to do, so thank you.
Ms. Falgood, could you do us a favor? There's some background noise, and speak right in that microphone because we want to hear every
Sure.
word.
Is that better, Your Honor?
And can we send somebody down to ask them to stop doing what they're doing just during the argument?
Please proceed.
Thank you, Your Honor. There are basically three major issues that have been raised here. First is the timeliness of the employer's appeal. The record on appeal reflects that the appeal was filed late, and at most, this court should remand to ADES for fact-finding as opposed to actually addressing that issue. Or the court could rely on the record on appeal and find that the appeal was untimely. I'll address that in more detail shortly. The second issue is that the appeal tribunal, the administrative law judge, made erroneous factual findings and misapplied the law in overruling the deputy's determination of eligibility. So if this court decides that it's going to address these issues, would request that the court recognize those errors and find that was in error, and that the appeals board essentially compounded that error by relying on the appeal tribunal's decision and also misapplying the law. Both the appeal tribunal and the appeals board failed to obtain and consider evidence that was clearly available, and both found it relevant. In fact, relied on the fact that the medical records had not been provided in dismissing the appeal. In finding her not eligible. And so to the extent that those records would have been important to consider, both the appeal tribunal and the appeals board had the duty and the obligation to ask for them. Ms. Hauser testified that they existed, and the tribunal and the board should have asked for them. So going into a little more detail on that first issue about the appeal being untimely, Arizona Revised Statute Section 23773B provides that if a party does not appeal the deputy's decision within 7 calendar days after the delivery of notification or within 15 days after it was mailed, then it shall become final and benefits shall be paid. That's pretty straightforward. The latest deadline.
Is that a jurisdictional requirement in your view?
In my view, I'm not sure if it's jurisdictional. It could be jurisdictional. It certainly has been interpreted that way in some cases. Additionally, though, it is a bar to recovery. The only thing that makes me hesitate about calling it strictly jurisdictional is that the regulation R6-3-1404B provides some limited exceptions to that 15-day time limit. And so there's no indication in the record on appeal that any of those apply here. There's nothing in the record on appeal about a decision being made about the timeliness of this appeal. Yes, Your Honor.
And a regulation could not alter a bar by statute.
That is correct. That is correct. So to the extent that regulation applies, maybe it's not jurisdictional, but those conditions have not been demonstrated to have been met. Alternatively, it's jurisdictional, and the deputy's determination should stand. The subsequent proceedings should not have taken place.
I guess the argument about time that's been waived by the employers did not timely challenge.
Well, Ms. Hauser had no notice of it, and additionally, to the extent it is jurisdiction question, that is not waivable. If the tribunal didn't have jurisdiction to make the decision it made, that's a void act. That's a void decision. The statute is clear. Based on the record on appeal, the employer did not timely appeal. That decision should have been final.
And counsel, when you mention lack of notice, is that she didn't know the facts surrounding it, or it wasn't noticed by the agency?
So I don't know what DES knew or didn't know. Again, there's nothing in the record on appeal demonstrating that any decision was made about whether it was timely. My reference is to the fact that Ms. Hauser would have had no way of knowing whether that thing was timely submitted to DES or not until she got the record on appeal and could see that it apparently was submitted on November 26th, and that is too late. So, given that she didn't know that it was untimely filed until this appeal, I don't see how she could have knowingly waived that argument. The department asked this court to consider some additional records from the department and take judicial notice of them in deciding that the appeal was in fact timely. The court should decline that request. First of all, the records are pretty cryptic. I looked at them and I couldn't. Yes, Your Honor.
I wouldn't waste time on that, just because. Let's move on to the other portions, because I agree, it's not part of the record.
Okay.
So, moving on, let's talk about what is the ALJ's obligation when a good cause kind of excuse is given for qualifying for benefits. What is the ALJ's obligation to pull that information out, if not pro-offered by the claimant?
So I don't know that the ALJ has a huge obligation to do discovery like an attorney would do, but certainly to the extent that something is relevant. For example, the statutes or the regulations anyway, require that there be some kind of medical opinion about it. So certainly it should be on the ALJ to ask, are there some medical records? Can you present them? Perhaps continue the hearing and allow the person time to bring them. I think that these regulations, we have the regulation that says, it's R6-3-50190, that says the adjudicator must obtain all pertinent evidence reasonably available to make a non-monetary determination, such as eligibility. So given that obligation, certainly when it has come to light that these medical records were provided to the employer and do exist, the adjudicator had the obligation to try to obtain them. Now, if they ask for them and the person doesn't provide them, then they have failed to sustain their burden of proof. But when they haven't even been asked to provide them, that's not a fair thing to do. And I'm pretty sure these regulations were implemented in part because, think about what's going on in an unemployment case. You have somebody who's just been fired, right? Or has just quit their job, one or the other. They don't have income right now. How are they going to hire an attorney to help them through this process? And so the regulations, I believe, are designed in part to ensure that we have a fair tribunal. And frankly, it works for the employer too. Most of them are not represented by attorneys either. They are showing up with a manager or some person that represents the company, but they're not lawyers either. It works both ways. If the employer had said, oh yeah, well, she submitted medical records, but they didn't show anything relevant to this, the tribunal would have had the obligation to ask the employer to provide this so that it could evaluate whether that was true or not, and not simply take Ms. Hauser's word that they showed what she said they did.
And indeed, in these administrative proceedings, unlike court proceedings, a corporate entity can represent itself without retaining counsel.
That is correct, yes.
I'd like to hear a little bit, because I'm a little confused about the allocation of the burden of proof within the administrative process. It seemed to me the ALJ allocated it to the former employer, and the appeals board viewed it kind of differently.
Yes, I think that's correct, Your Honor, that is what happened. And it is my understanding that the burden of proof at the appeal tribunal level falls on the person who has brought the appeal to the tribunal. They have the burden to show that the deputy's determination was incorrect. And so the appeals board may have gotten that wrong as well, to the extent that it was placing the burden on. Now, the appeal tribunal, the ALJ, did state that Ms. Hauser, that the employer had the burden of proof and let them go first and have rebuttal and everything. But then in its decision, it still seems to be saying, oh, but she didn't provide these records and therefore she loses. Well, it should have been, well, the employer didn't provide anything to refute the fact that she was on this short-term disability leave for medical reasons related to work. They had the burden to prove that, and they didn't. And so, again, the hearing officer seems to have made clearly erroneous factual findings. I found it interesting, too, that the appeal tribunal found that she didn't submit the records to her employer when everything at that hearing suggested that she did, in fact, give medical records to her employer. No employer grants you short-term disability leave if they don't have some kind of medical records showing that it's necessary, right?
Now, I was a little unclear, and this is a factual issue, so explain this to me. Was it a third party that was providing the disability benefits that would have received those records, or was it the employer?
Well, so the employer was Liberty Mutual, and interestingly, the insurance was Liberty Mutual short-term disability. My own experience, I know that's not really relevant, with short-term disability is that your employer is well aware of it. I mean, HR has to know that you're going out on short-term disability leave as well. I don't know whether she was required to submit those records to HR or not. I do know that she submitted them to Liberty Mutual, and it seems a little unfair to have Liberty Mutual, having the right hand say that it didn't know the left hand got these things. And in an event, like I said, HR certainly would have had to be aware that she's on short-term disability leave, and her supervisor as well, and that there's a medical reason for it. But interestingly, the regulation that talks about that says that it's unclear. It doesn't really say who it has to be submitted to, but it does say that you have to have either the medical records or witness testimony or the adjudicator's determination that the person, had a good reason. And so, in my view, that seems like it is saying you have to submit this stuff to the adjudicator, and that's what makes sense, right? The person who's making the decision, whether that's the deputy, the appeal tribunal, or the appeals board. And so,
But in fact, didn't your client testify during the hearing about her medical disability, and shouldn't that have been enough according to this?
I believe it should have been. She is a witness. She testified. She didn't just submit her form and not show up at the hearing and wait for it to be denied. She came and testified and gave evidence, would have provided the documents if she had merely been asked to do so. I'm not even sure the documents were necessary or relevant. I mean, I feel like the appeal tribunal really should have relied on the fact that she was out on the short-term disability for job-related medical issues, and absent the employer providing those records to say no, that wasn't the reason for it, then the court should have, or the appeal tribunal, not the court, should have upheld the deputy's determination. Again, the employer had the burden to prove that it was wrong, and in my view, they clearly did not carry that burden. The appeal tribunal, again, made several clearly erroneous factual findings, the most relevant being that she didn't submit the records, the medical records. She did submit them to the employer. Not sure that it was relevant whether she'd submitted to the employer or not, but to the extent that the appeal tribunal was relying on the idea that she didn't submit medical records to somebody, that's incorrect. She submitted them to the employer, would have been happy to bring them to the ALJ. The second really relevant issue was his finding that the new job was, quote, identical to the old one. Despite his recognition at the hearing that it had a new title and additional job duties, and despite Ms. Hauser's eyewitness testimony that it was substantially different, she had no training, no support, she didn't know answers to questions, they were working at home during COVID with no access to a supervisor to assist her, that was a substantially different and more stressful situation than the prior job that she had had working for Liberty Mutual. And so this is not a situation where, she just decided she didn't want to work there. She gave it a fair shot. She showed up, she tried to make it work. It wasn't working. She asked to go on short-term disability leave, just like the regulations require, try to solve the problem, right? Try to resolve the issues that are causing the problem. And then when she came back and tried again and still was getting no training and no support, she asked to be transferred back to her old position, and they said no. She did everything those regulations require before quitting based on this medical disability.
Let me ask you a question. What is the, to digress for a bit, but what is the legal significance in your mind that Liberty Mutual is not here today or did not file a brief? Even though it filed a request for, in my understanding, an extension of time to file a brief.
Right, yeah. You know, I have to say, Your Honor, I've always thought these unemployment appeals were a little odd, that the tribunal representative, you know, ADES shows up to essentially represent its appeals board and try to argue that they made the right decision instead of putting the burden on the other party, the one who is having the claim decided against it to show up and defend it if they want to. So, you know, my understanding that employers almost never show up for these things, so I don't know that you get to read much into that, but I wish you would. I would love to see this court issue a decision that can count against the employer if they don't bother to show up and contest it. Ms. Hauser has had to figure out a way to contest this, and you know, why isn't DES representing her instead? I don't understand. Well, I'm going to go ahead and reserve my remaining time unless anybody has any additional questions right now.
Very well, thank you.
Thank you, Your Honor.
Thank you. Ms. Stokes, before your time begins, I realized our sign-in sheet was wrong apropos to this last exchange. You're counsel for Appley ADES, not SPT or Liberty,
Oh, yes,
correct?
I'm sorry.
No, that's on me. That's on me, but I'm going to make that change and initial it, so there's,
Thank you.
you bet. Very well, Ms.
Thank
Stokes.
you. Good morning, and may it please the court. My name is Emily Stokes. I'm an Assistant Attorney General, and I do represent the department in this matter. The case before this court is ultimately quite simple. It's did Ms. Hauser prove her eligibility for benefits?
It's not that simple. So let's start at the beginning. ADES submits the record to us and certifies with a nice little gold seal that everything in here is true and correct. So we have all of these documents that are filed, and based on your department's your client's representation, the document at issue regarding the timeliness issue was filed 3 days late. Would you agree with that?
What I would say is that the index of the record, which is a tool to allow this court to understand the record, contained a typographical error. But the actual record, which is the evidence before the department and any records of which the agency chooses to avail itself, has the application dated for the correct date.
Okay, we have Liberty Mutual providing a document that they provide the date on. It has absolutely nothing that says when the department received it. And we have certain regulations that determine when the department received it. So why should we not trust the index of the record about what the department said, which was, we received this 3 days late?
Because of the fact that a hearing, in fact, got set. The department wouldn't have set a hearing if the application had been untimely. It would have sent a notice out to the party saying your application is untimely, which would have triggered the next part where the person could ask for it to be treated as timely.
Okay, pause for a moment. So we're just supposed to take the department's word for it, even though it's not part of the record?
No, the court doesn't just have to take the department's word for it. The department has submitted additional documentation plus an affidavit from the administrator.
Whoa, wait a minute.
Yes.
When we talk about the record, we've got the record. Additional documentation, are we supposed to just take that on faith, just bring it in and make it part of the record? I mean, I get we have discretion to do that, but we're not required to do that, are we?
The court's not required to do that. If the court believes that there is an issue here regarding that, it can remand for a hearing on the issue. It should not remand and simply affirm the deputy's decision. At the end of the day, if there is a factual dispute here, which there would appear to be, the remedy would then be to remand for a hearing where the department could flesh this out. At that hearing, the department would submit the documents that it's already submitted to the court, which is an agency record. It's the type of record that the department would normally rely on when deciding whether something is timely. And so for the interest of judicial economy, And the fact that this court does have the ability to take judicial notice of an agency record, we would ask the court to do that in this case. There is indicia of reliability. We do have the affidavit from the administrator of the Appellate Services Administration.
Counsel, can I ask you,
Yes.
we'll get to the
Yes.
affidavit because I have some questions about that in a second. But the hearing, the initial hearing in front of the ALJ was on the 7th of February, 2022, right? And the question I have is when that hearing was set.
I believe the hearing would have, I actually am not sure when the hearing itself was set. I don't know exactly when the hearing was set, but it was obviously, it was set after the employer sent in the appeal request.
Right, and I guess I'm pushing a little bit on your point that, well, a hearing never would have been set on an untimely application. The application was received sometime, and let's set aside exactly when for just now, in late November 2021. And the best I can tell from the record, this claimed error was identified on the 13th of January. That's the documents attached to the affidavit. It would seem to me that the hearing would have been set sometime before that.
I know that the department around that time received a lot of applications, and it took time.
Very well aware of that.
Right, to process things. And so it may have taken a while for it to enter into the system. But this is the kind of information that the department would normally rely on when setting a hearing.
And I understand that, and it just seems to me that if the hearing was set before the 13th of January, that would run counter to your argument that an untimely hearing never would have been set.
Normally, these types of decisions are made behind the scenes. There's never really a hearing regarding whether it's timely unless it's untimely. If it's untimely, that triggers the hearing that is laid out in the regulation where the party can say, well, it's untimely because the post office made a mistake or you gave us bad information. But if it's timely, the department just takes it and dockets it and sets the hearing.
And that, well, I think saying the same thing, it
Yes.
just, that would obtain, if the hearing was set before the 13th of January, I would want to know why, if the documents, which they appear to before that time, suggest the application for a hearing was untimely. Because I thought I heard you say the department would either never or almost never set a hearing on an application that they viewed as untimely.
Right. If it gets the application and it's timely, it goes ahead and it sets the hearing automatically. If it's untimely, it sends the notice saying this is untimely, which triggers then the right to the hearing about whether it should be treated as timely.
Understand, and my question was really the setting in this specific case.
It appears that after processing it on January 13th is when the department sent out the notice to then set the hearing.
Where would I get that from the documents?
Well, the hearing notice itself should have an issuance date. The mailing date was January 19.
19.
So it was a few days later.
And that was really my original question, so we've gotten there, thank you.
Okay, thank you. So now, to the merits of the case. Ms. Hauser, she did voluntarily quit her job. And so the statutes and the regulations make clear that where there's a voluntary quit, it is the claimant's burden to prove that she is eligible for benefits.
Is that what the ALJ said at the hearing?
The ALJ did seem to mix up the burden.
Right.
And to believe that the employer, because they initiated the appeal, had the burden.
Correct.
But the regulations and the statutes do make clear that if there's a voluntary quit, then the burden does shift to the claimant to prove her eligibility.
What are we to make of the fact that apparently, and I think both sides agree, that the independent finder of fact confused the law upon which a decision was to be made?
Well, I would say that that's why we then have the next level of appeal before the board. The board did state the proper legal, the legal standards that exist, and the board applied it properly. And I would say that in this case, Hauser was given every chance to sustain her burden.
Well,
Yes.
that depends on what her burden was, and the ALJ, the one person she saw when she took an oath and testified, said, you don't have the burden to show things. Isn't that kind of the record as it sits?
The ALJ did suggest, yes, that the employer had the burden, but
And actually, LJ said that, right? I don't know that there was a suggestion to it.
yes, but Ms. Hauser still, at the end of the day, she had access, when the department issued the notice of hearing, it gave her the sections of the statutes and the code that apply to her. It was on her to prepare, it was incumbent on her to be prepared for her hearing, and she was told, this is your one opportunity to tell your side of the case.
What should she have done when the ALJ said, you don't have the burden, the employer does, at the hearing?
Well, I think the best she could do, again, she was told this is your opportunity to tell your side of the case. And so she still then did have her opportunity to prove up her claim. Her claim is that she had to leave for a health or physical condition.
But when you say prove up, that assumes she had a burden, and the ALJ had just told her she didn't.
Again, it was her obligation to show up to the hearing and to be prepared for it.
And she did.
She was not prepared for it because she didn't, in fact, substantiate her claim that her leaving was for a health or physical condition.
If she had the burden and wasn't told that she didn't.
She offered sworn testimony to that effect.
So the department, in evaluating this case, the board evaluated the fact that she had provided her own testimony and decided that that doesn't count as a witness statement. And that makes sense.
Do we know that the board listened to the recording? Are we supposed to presume that in every instance when the board says that they actually did listen to the recording or read the transcript?
I
Or
believe,
do we know the difference there? Sorry, that's a lot of questions, but how do we know that the board, A, listened to the actual recording, or B, read the transcript?
well, we know from the record that the board said she testified. She offered her own testimony on
But
this
we don't know
fact.
if it was a cold record or if it was...
We don't,
listening.
based on this, but we do know that the board knew that she had testified, and it decided that wasn't good enough, that there needed to be something else. The department's regulation on this point makes it clear that the claimant's word for it isn't enough. Something else
But we
needs to...
have more than that, don't we?
At the end of the day, no, we don't. We have her
Yes, we do.
testimony.
Hold on and let me point to the
Sorry.
record.
Okay.
So Index of Record 1, which is the transcript, page 17, Ms. Hauser is testifying, but she's testifying that she has this medical condition, and she's testifying that a third party already looked at this medical condition because she was granted short-term disability, and that medical records at the bottom of page 18 were provided to the employer. So we already know that this medical condition rose to the level that she was granted disability benefits, short-term. And we know that the medical records were also given to Liberty Mutual because she had to apply, was denied, appealed. So they had a lot of records, Liberty Mutual, you would agree.
I actually don't know, based
But
on...
it wasn't just her testimony. A third party had already looked at her medical condition and granted her benefits based on that medical condition. Would you agree?
Based on her testimony, that is what happened.
Do we have anything to counter that in the transcript?
The issue at the end of the day is, did she substantiate it to the adjudicator that she had to quit for that reason? Not that she took a medical leave previously. Did she quit for that reason?
And we have testimony and we have medical kinds of, do you see what I'm saying? The statute says it could be testimony, and she provided testimony. She provided testimony that had to have been verified by a third party because Liberty Mutual didn't challenge it.
Sorry, if I could just add, on that point, if there really is an FMLA issue, employers are supposed to keep it confidential. I'm not sure if Liberty Mutual could have really talked on that issue and tried to point out the other reason that she may or may not have taken a leave. I think at the end of the day, it's still important. The regulation makes it clear that the adjudicator has to receive either the doctor's statement, the witness statement, an employer statement, or an ALJ's observation. And again, it's to make sure there's indicia of reliability. A doctor has no interest in the case. The employer may be, in fact, saying something against his interest, which gives indicia of reliability. An ALJ observation, they're naturally presumed to be impartial. There's indicia of reliability. A self-serving statement, even under oath, doesn't carry the same indicia of reliability. The department created this regulation because it wanted something more. If a claimant could just say to the department or under oath, this is the reason I quit, there'd be no need for that regulation.
Okay, so where did Ms. Hauser receive notice that not only that her testimony would not suffice, that she needed to submit medical records before the hearing? Did she ever get notice of that?
She was given she was directed to the part of the administrative code that would affect the hearing, right in the notice of hearing, and she was told to be prepared for the hearing. And there is, in fact, an agency regulation that does say parties are expected to be prepared for the hearing with witnesses and documents, prepared to dispose of all issues.
Counsel, let me ask you, I assume the ALJs have training in this area, but the ALJ got that burden wrong, right?
The ALJ did state an incorrect burden, but again, at the end of the day, that didn't relieve her of her obligation to be prepared for the hearing. The regulation is very clear, it was her burden, and the regulation is very clear that she needed to substantiate it.
Let me ask
yes.
a related question. It's really a follow-up to what I think Judge Brown asked Ms. Falgout. What Liberty Mutual filed a notice of appearance here and actually asked for additional time to file a brief. It would seem to me that ADES has an interest in a fair proceeding. Liberty Mutual has an interest in a specific outcome. What should we make of the fact that Liberty Mutual then didn't file a brief? And you're here, and I think, but correct me if I'm wrong, to promote a fair process, not a specific result in that process.
Well, so ARS 41-1993B does explain that when an appeal application is filed, the department and all parties before the appeals board shall be given an opportunity to appear. Mm-hmm. So the department has the right to appear.
Yes.
And
but my question is
yes.
To do what?
It says here, and the cost of providing the record is a taxable cost if the department prevails. So it suggests the department does have the right to come here and to advance a position, and in this case, defending its final decision, which is the decision of the board.
So it's your position ADS has not only a right to advocate for a fair process, which
right.
is understandable, but in this instance to advocate the position of Liberty Mutual that the decision was correct.
It's to advocate its own position that the decision was correct. The department has an interest in promoting, in defending its position. Liberty Mutual would also have an interest in defending it. It is not here, but that doesn't change that the department also has its own personal interest in defending its position, and the statute gives it the right to appear and to try to prevail.
And so Liberty Mutual asking for the opportunity to file a brief but then not doing so would not, in your view, be a concession of error?
No, it would not, in my view, be a concession of error. Going back to, Ms. Hauser does make the claim that the ALJ has an obligation to affirmatively investigate certain facts and should be able to continue hearings to allow parties to enter in more evidence. But there are other, again, regulations that say parties actually have to be prepared when they show up to hearings, that when you go in front of the appeals board, you could present evidence, but only if it was newly acquired and couldn't have been presented at the original hearing. It shows that there's actually these competing principles that, no, you need to be prepared when you show up for your hearing. And so the department's position is that those, rather than being in conflict where we would say one's more specific than the other, this court should in fact interpret them to harmonize with one another. That in fact, yes, the ALJ should try to get all pertinent information reasonably available, but if it's not there at the hearing and readily producible, it's not readily available. That's a way to harmonize the two positions. And I would point out that there's the case Dowdy versus the Employment Security Commission, where this court held that the department, there may be times where the department needs to take a more active role in the fact-finding process and may need to take independent steps to find more information. But the theory there was that the department is sometimes in a superior position to the parties to get this evidence. In this case, the department was not in a superior position to get Hauser's medical records. Only Hauser was in the position to get her own medical records. So the rationale in Dowdy does not apply here. This is a case where she had the burden, the onus, to bring those records forward. And if we were to take Hauser's rule and apply it broadly, not just to these kinds of cases, it would essentially mean that in any hearing, if a party says, you know what, I have a witness who could actually speak directly on this point, the ALJ would have to give them another opportunity to call in that witness. And this could become a completely unworkable solution given the amount of cases the department has.
Counsel, can we speculate on what would have happened if the ALJ at the beginning of the hearing had properly stated what you believe is the burden of proof?
Well, again, it appears that she didn't submit her records prior to the hearing. So we'd find ourselves in the same position, which is she didn't, in fact, provide a doctor statement, a medical statement, employer statement. She'd still find herself in the same exact position, even if the ALJ had said the correct burden at the beginning.
How do we know that?
Because we know that she didn't show up with the actual records at the hearing. The notice of hearing says these need to be submitted ahead of time because the parties need to have a chance to be able to review it, to issue objections. You know, we know for practical and fairness purposes, she needed to take some steps ahead of the hearing to get either a witness list or get these documents in front of the ALJ, and she didn't do that. So regardless, she was in the same position regardless.
One, sort of taking things out of order, with respect to the timeliness issue, you had argued, I think, in your brief waiver. Do you want to address that here today?
Well, yes, so this court's jurisdiction is as provided by statute. The statute in this case says that an issue may not be raised on appeal that was not raised in the petition for review to the board. And then, of course, a court always has jurisdiction to consider its own jurisdiction. But that doesn't necessarily follow that it always has jurisdiction to decide whether an agency exceeded its authority. So in this case, it is our position that this court does not have jurisdiction to consider the timeliness issue, though it's also our position that the department did not exceed its authority, and we have provided this court with the types of evidence that can be considered when making a jurisdictional decision. There's case law.
Does the department typically view a failure, hypothetical failure, okay, so let's remove ourselves from the facts of this case, disputed or otherwise, but does the department view the failure to timely seek review of a deputy's determination as jurisdictional? The case is over if that doesn't happen.
Well, again, because of what Ms. Falgett did point out, because there are some exceptions and there could be a hearing on it, I don't know that it would be.
Let's carve those out because that would require some request by somebody to do that. But just as a matter of standard, comparing dates on a calendar or a time wheel for timeliness, does the department view that as jurisdictional or not?
I think it's more viewed as its authority. Does it have authority to do something versus whether it has jurisdiction to do something?
And, well, what's the answer with respect to authority? That it lacks authority?
It would lack authority to do something if it's untimely.
We have consumed much of your time. If you wish to briefly wrap up, we'd be happy to hear.
Thank you, Your Honor. At the end of the day, again, it was Ms. Hauser's burden to prove that she had eligibility for benefits. The board properly applied that standard, and she did not do that. So we would ask the court to affirm the board's decision. Thank you.
Thank you. Ms. Falgett, rebuttal.
Thank you, Your Honor. Just a couple of points in rebuttal. Ms. Hauser did carry her burden of proof. She proved to the deputy that she was eligible.
Pull your microphone closer.
Thank you. She proved to the deputy that she was eligible. Then we have an appeal to the appeal tribunal. And much like our court system, when you take it up a level, you have an obligation, the person who's doing the appeal has an obligation to show that the underlying decision was incorrect. And I think that's what the ALJ probably meant by burden of proof. They had the obligation to prove that the deputy's determination was incorrect. Ms. Hauser had already carried her initial burden of proof to show that she was eligible. The deputy talked to her on the phone, reviewed whatever had been submitted with the initial application, and concluded that she was eligible. On the appeal to the appeal tribunal, which is a little different from the court in that it's a fact finder.
What do you make of Ms. Stokes pointing to the regulations saying she was required to submit medical records based on the good cause exception being medical?
So that's the regulation actually gives three different ways that you can prove that. One is with medical testimony or records, another is witness testimony, and the other is the adjudicator's own determination. So she carried that burden. I would also like to point out, this is not as cut and dried as, oh, she was told that she had to show up and be prepared. R6-3-50190C says, evidence must be evaluated during the course of adjudication to determine whether it is sufficient to make a decision. Sufficiency is reached when further rebuttal or circumstantial evidence will not alter the conclusions of the adjudicator. Both the appeal tribunal and the appeals board found that those medical records were necessary in order to evaluate whether she actually had this medical condition that was caused her to quit her job, and that those records weren't there, and therefore she loses. But that means that the tribunal didn't do its job of making sure that there was adequate evidence in the record. It didn't do its duty to evaluate the evidence during the course of adjudication to determine whether it's sufficient and to obtain any reasonably available evidence if the evidence isn't there.
Can you repeat that regulation number?
R6-3-50190C.
And if we go up to B of that portion, where it talks about the burden of proof rests on the individual who makes the statement, and the statement was that she had this medical condition that rendered her unable to continue in her job, is there any information in the transcript where the employer disputed that?
Disputed the fact that she left for that reason?
Correct.
Not, the only things that I remember from the transcript, and I believe I addressed that in the brief as well, so there may be more that I'm not remembering right now. I do remember that the employer did not contest that she had been on the short-term disability leave based on a medical condition, said some words, I can't remember the exact words, but that were consistent with the idea of her leaving due to the job-related anxiety and depression issues that she had. I think she said she was uncomfortable or not comfortable in the new position.
So that statement was, her medical testimony was never disputed by Liberty Mutual?
Correct.
Okay.
Correct. I just had one or two other things. Judge Thune had brought up a point that I agree with totally, in that ADES has an interest in a fair proceeding. And as outlined in the brief, I don't think this proceeding was particularly fair. Despite having medical records readily available, no one ever asked for them. Despite the fact that she was told that the employer would have the burden of proof at that appeal tribunal level, in fact, the appeal tribunal concluded she had improved her case. She did prove her case to the deputy. By the time it got to the appeal tribunal, it was the employer's burden to show that that decision was incorrect. I think the appeal tribunal got that right. Yes, she had the obligation to prove her case, but she had already done so to the deputy. The department stated that Ms. Hauser was in a better position to obtain the documents talking about that Dowdy case. But again, even that case recognizes the tribunal's obligation to at least ask for relevant evidence. If the tribunal had asked for those records and she couldn't produce them, we might be in a whole different position here. But instead, the tribunal and the appeals board both simply relied on the lack of the evidence without ever having performed their duty under the regulations to ask for it, to evaluate whether evidence was sufficient and ask for it. I ask that you find it untimely and just simply reinstate the deputy's decision. If you do reach the merits, I ask that you find that the deputy's decision should have been upheld. Thank you, Your Honors.
Thank you. Counsel, we appreciate your presentation today. We appreciate your briefs. We will take the matter under advisement. We'll issue a written ruling in due course. Court stands adjourned.